Hi guys, welcome back to another video with Pratham Test Prep. This is your host Sanjeev Bhatia again with another video on your legal terms and legal maxims. Right, so there are a lot of people who are trying to go for CLAT 2022 or AILET 2022 or any other law entrance exam. These kinds of maxims can be asked to you very, very regularly. Right, so you have to make sure that you are well aware about these legal maxims and legal terms that might pop up in your examinations very, very regularly. Okay, so before we move ahead, the same request that I make to every one of you is to hit like, share and subscribe button. If you don't know me, my name is Sanjeev Bhatia. I'm a graduate from National Law University Bhopal myself, and I've been training multiple thousands of students around the globe for their CLAT and any other law entrance preparation, right? So a like, share and subscribe will be great. If you have any other queries regarding our Telegram channel, you can be a part of the Telegram channel under the name of CLAT@Pratham. We provide you free updates, any material that you require, our session updates also. And if there's anything new that is coming up inside the law entrance test prep market, we also make you aware of that, right? So you can definitely join our Telegram channel under the name of CLAT@Pratham. Okay. Now, if you have any doubts, if you want any mentorship, or you think that you need test series, you need materials, you can definitely give us a call on 5 times 9 75392. Keep a screenshot of this number. If you want to catch hold of me also, you can call on this number and you can get through, right? So starting with the legal maxims and the terms for the day, right? For the first legal maxim of the day is ratio descendi. Now, what do you mean by ratio descendi? Where is it used? Right? So it is basically the reason or the rationale for the decision that is given by the court. Right? So the court has to give a reason that why are they giving such a decision? What is the rationale behind giving such a decision? So the reason or the rationale behind the decision of the court comes under the definition of ratio descendi, right? So this will be a very, very largely used term under the law school arena also. Once you'll be in the law school, then you'll be reading a lot of ratio descendi, right? Why? Because these are the reasons or rationale for which the court has given such a decision. So a lot of law schools also, if you make sure that when you'll be there, there will be a lot of problem-based questions that will be given you. They'll be give you a real life problem-based solution, like problems. And now you have to put all these laws, you have to apply these laws in these real life problems, right? So you have to use the ratio descendi of a lot of cases that are there, that are being taught to you in your class at the law school arena, right? So you will use the reason and the rationale from those cases. Basically, you'll use the ratio descendi from different cases and put it in those real life cases that are given to you in your examination with your arguments on the same, right? So ratio descendi is the first term of the day. That means the reason or the rationale for the decision by the court. Now, I hope everybody is clear with this term called ratio descendi. Now, coming to the next term for the day, that is obiter dicta. A lot of people get confused between ratio descendi and obiter dicta. Now, what is obiter dicta? Basically, it is the remarks of a judge, right? Which are not necessary to reach a solution or a decision, but are made as comments, illustration, or thoughts, right? It is a very, very simple term. So you have to see the reason and the rationale that is given behind a decision is called ratio descendi, right? But if there's any view, right, which might not lead you to the decision, which is not leading the judge to a decision, right, that kind of remarks, okay, comes under the category of obiter dicta. Now, these remarks can be comments, they can be illustration, or they can be just random thoughts of the judge, right? So they all come under the category of obiter dicta. Now, this is a very, very simple term that you have to realize is that these are just remarks. These are not decisions. These might not lead the judge to the decision also, but these are sheer remarks that are being given in the courtroom. So they come under the category of obiter dicta. Now, coming to the next term for the day, that is actus non facit reum nisi mens sit rea. Now the act does not make one guilty unless there be a criminal intent. ये हमने बहुत ज्यादा आप ये चीज को नोटिस करेंगे जब आप क्रिमिनल लॉ पढ़ रहे होंगे, that the act itself doesn't make anyone guilty, right? But there has to be a criminal intent. Malified intention के बारे में बात होती है, mens rea के बारे में बात होती है, which is bad intention. So there has to be bad intention behind your back if you are coming and committing something which is guilty in nature, right? Actus rea से आपने action किया है with a guilty mind, that is mens rea. So actus non facit reum nisi mens sit rea. Basically the act does not make someone guilty but until they have a criminal intent. For example, in the case of theft, right? और आप एक example लीजिए कि एक आदमी था राम जो अपने दोस्त के पास गया शाम के पास, right? He picked up a book from there as he used to do it in college and he took away the book. Now there is a action that is there, okay, which is which can be said to be theft, but there is one missing thing in this, which is the criminal intention, the mens rea to steal that book. He just picked the book and left, right? There was no criminal intention that is defined here. So basically the act here is not making Ram guilty of theft, right? But because there was no criminal intention in this case, right? So that is what you have to understand by the term actus non facit reum nis means sit rea, right? Very simple, nothing very complicated here to understand also. Chaliye. So the next term for the day is amicus curiae, right? This is a term that you will hear a lot nowadays inside the newspaper also. This is a very regularly used term, that is a friend of the court or a member of the bar which is there appointed to assist the court, right? It is as simple as that, right? एक दोस्त है जो कोर्ट का या बार का, ठीक है, जिसको अपॉइंट किया गया है to assist the court. There can be some cases where the bar will find itself not to be the expert in the case, right? अगर आप सोचिए कोई forensics का केस आ जाता है या फिर कोई बहुत ज्यादा माइन्यूट एक इंडस्ट्री है, जैसे शिप ब्रेकिंग इंडस्ट्री आप ले लीजिए, उसका माइन्यूटली कोई एक प्रोपेलर का केस आ जाता है, राइट? सो द कोर्ट एंड द जजेस हु आर सिटिंग देयर आर नॉट एक्सपर्ट्स ऑन दीज मैटर्स, राइट? So definitely they will bring in an expert. Now this expert will be called as amicus curiae, right? So amicus curiae is a friend of the court or of the bar who is appointed to assist the court. Basically, if any assistance is required by the court and any person who is appointed is called amicus curiae. ठीक है? In the High Court or is it in the Supreme Court? So the law of the forum means the law of the forum where the case is being heard. Very simple, nothing complicated in this term. So you can definitely learn this as law of the forum where the case is being heard. जहाँ पे केस सुना जा रहा है उस जगह का law क्या है, right? Very simple, lex fori. Let's come to the next term, that is respondent superior, right? Let the master answer. Basically strict liability का केस होता है या कोई भी ऐसा केस होता है जिसके अंदर मास्टर लाइबल होता है अपने एक्ट सर्वेंट के एक्ट के लिए, right? Or employer is liable for the act of their employees, then I'm really sorry, they come under the category of respondeat superior, right? Let the master answer here. Okay, so very important term that can be used in the law of torts also, and you can see that the master is the superior, so the master has to answer about every act that is committed by the employee in this regard. Okay, very simple term, very simple meaning of the term also. Let's come to the next term for the day to it, right? An injury is not the who is consenting to it. ठीक है? For example, आप एक कार रेस देखने गए, सोचिए आप नैस्कार या F1 की एक रेस देखने जा रहे हैं, आप मोटो जीपी देखने जा रहे हैं, ठीक है, बाइक की रेस देखने जा रहे हैं, एंड यू आर सिटिंग ऑन द स्टैंड्स, राइट? आप साइड में बैठे हैं, जहाँ रेस हो रही है वहां पे आपके स्टैंड्स बने हुए स्पेक्टेटर्स के. अब एक गाड़ी आती है या एक बाइक आती है जो डिसबैलेंस हो जाती है, इट लूजेस इट्स बैलेंस एंड क्रैशेस इनसाइड द बैरिकेड, और वो गाड़ी उठ के पब्लिक में गिर जाती है और आपको भी उसके अंदर चोट आती है, ठीक है? तो अब क्या इस केस में आप ऑर्गेनाइजर्स को हेल्ड लाइबल कर सकते हैं? ऐसी एक इंजरी के लिए, जबकि उन्होंने सारे एक बैरिकेड लगा रखा है, एक जाली लगा रखी है, तब भी गाड़ी उड़ के अंदर आ गई. तो कैन द ऑर्गेनाइजर बी हेल्ड गिल्टी इन सच अ केस? नो, he cannot be held guilty because he will claim the defense of voluntary non-fit injuria, right? An injury is not done to a person who's consenting to it. आपने consent दिया था कि मैं कार रेस देखने जा रहा हूं, अब कार रेस में जा रहे हो तो आपको कार एक्सीडेंट भी एंटिसिपेटेड है, गाड़ी उड़ के आ सकते हैं, ये भी एंटिसिपेटेड है, राइट? और एक और एग्जांपल आप ले सकते हो, आप क्रिकेट मैच देखने जाते हैं, बेसिकली यू आर सिटिंग इन द स्टैंड एंड यू आर वाचिंग अ क्रिकेट मैच, राइट? अब उधर से विराट कोहली ने सिक्सर मारा है और वो बॉल आपके आके सर पे लगती है, तो क्या आप एक ऑर्गेनाइजर को हेल्ड कर सकते हैं लाइबल कि नहीं, आपने, आपकी वजह से मेरे ऊपर बॉल लग गई? ठीक है, यहाँ पे इंजरी आपकी वजह से हुई है, आपने खुद कंसेंट दिया कि हाँ मैं क्रिकेट मैच देखने जा रहा हूं, तो आपको पता है बॉल आ सकती है, ऊपर से छक्का पड़ेगा तो बॉल आएगी नीचे. So basically you have consented for such an injury. So an injury is not done to a person who is consenting to it. It comes under the definition of voluntary non-fit injuria. ठीक है, तो अगर आपने कंसेंट दिया है और आपको इंजरी हो जाती है तो आप किसी को रिस्पॉन्सिबल हेल्ड नहीं कर सकते. वेरी सिंपल एज दैट. ठीक है, वेरी इजी डेफिनेशन, वेरी इजी लाइक लीगल मैक्सिम ऑल्सो, नथिंग वेरी कॉम्प्लिकेटेड हियर. सीधी सी बात है, किसी को इंजरी हो जाती है जिसके लिए उसने कंसेंट दिया, बात खत्म. आप बॉक्सिंग मैच का दिमाग में रखिए कि आप बॉक्सिंग खेलने जा रहे हैं, आप बॉक्सिंग करना चाहते हैं, आप बॉक्सिंग में सारा ग्लव्स, पैड, सब कुछ, अपना हेड प्रोटेक्टर सब कुछ पहन के जाते हैं और वहां पे आपको मुक्का पड़ता है और आपका जॉ टूट जाता है, राइट? सो इसमें आपने कंसेंट दिया, आप बॉक्सिंग करने गए तो आपको पता है कि बॉक्सिंग के अंदर एक जैब आपको पड़ सकता है, राइट? सो you are very well consented to it, that's why you are there. So there is no injury, there is nothing that the person can claim, right? And this is an injury where the person has consented to it, simple as that. Chaliye, so the next term for the day is actus die nemi facet injurium. Very long legal maxim, but definitely very, very easy meaning. Okay, an act of God does wrong to no one, right? There is no responsibility in damages for inevitable accidents. The act of God is prodigious to no one. The law does not hold a man to legal duty where he is prevented from performing it by an act of God. ठीक है, आप समझिए आपने किसी इंसान के साथ कॉन्ट्रैक्ट किया, ठीक है, कि मैं आपको गुड्स भेजूंगा इंडिया से, आपको जाएंगे गुड्स आपके जर्मनी, राइट? ठीक है, आपने कॉन्ट्रैक्ट कर लिया किसी के साथ. अब इंडिया के अंदर जहां पे आपके गुड्स रखे हैं वहां पे बाढ़ आ जाती है, राइट? या फिर वहां पे जो पूरी जगह है वहां पे अर्थक्वेक हो जाता है या सुनामी आ जाती है, राइट? सो इसमें एक्ट ऑफ गॉड है ये, आप इसमें कुछ नहीं कर सकते ना, जिस बंदे ने आपसे कॉन्ट्रैक्ट किया वो कुछ कर सकता है. सो बेसिकली हियर द गॉड हैज टेकन दिस थिंग इन हिज हैंड. Now an act of God does wrong to no one. किसी के साथ कोई ब्रीच नहीं हुआ है यहाँ पे, because there was an act of God and it is inevitable. अब सुनामी आ गई तो मैं थोड़ी ना गुड्स जाके ट्रांसफर कर सकता हूँ या आपको हैंड ओवर कर सकता हूँ. It's impossible. This is an inevitable accident, right? So when there is an inevitable accident, you have to see that you have to make sure that it is coming under the category of act of God, right? So you have to see that act of God is something that does not do prejudice to anyone, right? And it is an inevitable accident. It comes under the category of inevitable accident, right? So that is what you have to understand here. ठीक है, चलिए next is edificium soil solo cadet. It's a very easy. Who is built on the land goes with the land. What is built on the land goes with the land. ठीक है जी. One may hold the soil but other may hold the building. ये इंडियन कॉन्टेक्स्ट है, पहले आप ऊपर का कॉन्टेक्स्ट समझिए जो कॉमन लॉ कॉन्टेक्स्ट है. What is built on the land goes with the land. ठीक है, तो लैंड पे जो भी चीज बनी हुई है, ठीक है, वो लैंड के साथ ही जाएगी. ठीक है, अब लैंड पे अब खंबा गड़ा हुआ है या फिर वहां पे एक फार्म बना हुआ है या हमारा एक पॉन्ड बना हुआ है, तो वो जो भी है वो लैंड के साथ ही जाएगा. बट इंडियन कंटेक्स्ट के अंदर क्या हो सकता है कि एक इंसान हो सकता है जो सिर्फ लैंड ओन कर रहा है और एक इंसान हो सकता है जो बिल्डिंग होल्ड कर रहा है, ठीक है, उसी लैंड पे एक बिल्डिंग है वो एक दूसरे इंसान के, और जो लैंड है वो एक दूसरे इंसान के, ये हो सकता है, ये इंडिया के कॉन्टेक्स्ट में दिस इज अ पॉसिबिलिटी, राइट. सो वन में होल्ड द सॉइल बट द अदर में होल्ड द बिल्डिंग, राइट. सो दैट इज व्हाट इज वेरी वेरी इंपॉर्टेंट इन दिस केस, दैट एक बंदा सॉइल होल्ड कर रहा है तो दूसरा बंदा बिल्डिंग भी होल्ड कर सकता है इंडियन कॉन्टेक्स्ट के हिसाब से. तो एडिफिटम soil solo cadet, this is the term. Now the next is equitas non facit jus sed juri exitulare, right. Now what happens is equity does not create a right but aids the right. Equity cannot be basis of creating a new right, ठीक है. इक्विटी जो होती है वो एक नया राइट नहीं बनाती है, ठीक है, वो एक नया राइट नहीं बना सकती कि इक्विटी करने के चक्कर में हम एक नया राइट क्रिएट कर दें. दैट इज नॉट पॉसिबल, but it aids the right, it helps to put that right better way, in a better way forward, right. So equity always aids the right but it cannot create a new right, right. Equity cannot be a basis of creating a new right. That is what is being said in this legal maxim, that is equitas non facit jus sed juri auxilitor, right. So now this is the term, equity does not create a right, but it aids the right. Very simple, nothing very complicated here. So that is it for this legal maxim. Coming to the next legal maxim is that equitis nunquam contravenit leges, right. Equity never contravenes the law, right. जैसे अभी equity है पीछे, so equity never contravenes the law, right. So now the next is that equity cannot override the express provisions of the statute. Okay, so if there are any express provisions of the statutes that are there already existing, the equity cannot override the express provisions of the statutes, right. Where the statutes provides for anything, for doing a thing in a particular manner and in a particular time, it has to be done accordingly and not otherwise. The maxim is to supplement the law, not to contravene it. So जितनी आप maxims देख रहे हैं ये सारी law को supplement करने के लिए है, ना कि आपके contravene करने के लिए, ठीक है. Now this is very very important kind of maxims that you will read once you're inside the law school. Before the law school there are not very very important, but definitely if you have an idea it will be great for you once you're there also, right. So very important, so take a hang of it right away, so that will help you a lot. Now affectus punitor lecit non sequitur effectus, the intention is punished even if the object is not achieved, ठीक है. So अगर आप गए किसी के सामने, आपने बंदूक तान दी और उसने अपने सारे पैसे निकाल के आपको दे दिए, ठीक है, तो ऑब्जेक्ट आप पैसे निकाल के नहीं दिए पर आपने बंदूक तो तान दी, ठीक है. अब सोचो वो वॉलेट लेके भाग गया और पुलिस लेके आ गया, राइट. सो यहाँ पे आपका इंटेंशन उसको लूटने का था पर आप लूट नहीं पाए, ठीक है. सो योर इंटेंशन ऑफ हर्टिंग द पर्सन विल बी पनिश्ड, इवन योर ऑब्जेक्ट ऑफ टेकिंग अवे द मनी वाज not achieved in this case, right. So you have to understand that the intention can be punished even if the object is not achieved, right. So that is something that is really really important in this case. Okay, very easy legal maxims that I've taught you for today. Now the last one is accuser nemo debet se nisi coram dio, no one is obliged to accuse himself except before God. देखिए थोड़ी dramatic होती है legal maxims भी. तो देखिए no one is obliged to accuse himself, एक आदमी को अपने अगेंस्ट पे कोई भी एक्विजिशन करने की जरूरत नहीं होती है, right, except it's before the God. The prisoners at bar is fully entitled to plead not guilty whatever the facts may be, ठीक है. आपने अगर किसी का मर्डर भी किया है, ठीक है, तो आप फुल्ली एंटाइटल्ड है प्लीड करने के लिए that I am not guilty, ठीक है. Similarly, a witness may refuse to answer questions on the grounds that my reply might incriminate him, ठीक है, कि वो खुद ही फंस जाएगा, इंक्रिमिनेट कर लेगा, खुद के बारे में बता देगा या खुद एक्सेप्ट कर लेगा कोई क्राइम. तो अगर विटनेस ऐसा चीज बोलने से मना कर सकता है, he may refuse to answer any of these questions which can lead him to get incriminated on his own, right. This is also called the right against self incrimination, ठीक है. वेरी इजी, नॉट समथिंग वेरी कॉम्प्लिकेटेड, ये सब बहुत इजी है अगर आप देखें तो. सो इट इज ऑल्सो सेड एज राइट अगेंस्ट सेल्फ इंक्रिमिनेशन. कि मैं खुद को इंक्रिमिनेट नहीं कर सकता या मैं रिफ्यूज कर सकता हूं अगर ऐसा मैं विटनेस हूं और मुझसे कोई ऐसा क्वेश्चन पूछा जाता है जिससे मैं इंक्रिमिनेट हो जाऊंगा, so I can refuse to answer any of these questions. ठीक है? I hope you understand it very, very clearly. Last is actio non detor nom demificitio. ठीक है? Damnificitio is that is an action is not given to who is not injured. ठीक है? अब इंजर ही नहीं हुआ अगर कोई, तो उसके क्या फिर उसको एक्शन क्या दिया जाएगा? ठीक है? अगर उसको एक्शन नहीं दे सकते अगर उसको इंजरी नहीं हुई है, सिंपल एज दैट. तो आपको ये बात ध्यान रखनी है कि अगर किसी को इंजरी हुई है, ठीक है, तो वो पहले ये चेक करना है क्या वो लीगल इंजरी है या सिर्फ वो एक ऐसी इंजरी है. ठीक है? अब एक आपने वो ग्रामोफोन ग्रामर स्कूल वाला केस आप सुनेंगे जब आप लॉ पढ़ेंगे कि बेसिकली एक बंदे ने ग्रामर स्कूल स्टार्ट करा, उसके बहुत अच्छे क्लाइंट्स बन गए, बहुत सारे स्टूडेंट्स उसके पास पढ़ने आ गए, और उसी के सामने एक बंदे ने ग्रामर स्कूल खोल दिया. ठीक है? इंग्लिश ग्रामर का स्कूल, जिसमें कम लोग आ रहे थे पहले, पर उसने प्राइसेस रिड्यूस किए तो बहुत सारे लोग उसके ग्रामर स्कूल में आने लगे और इस वाले आदमी का बिजनेस फ्लॉप हो गया. राइट? सो हियर देयर इज एन इंजरी, देयर इज अ फाइनेंशियल इंजरी, बट इज देयर अ लीगल इंजरी? नो, there is no legal injury in this case. So an action is not given to who is not injured. अगर कोई injured नहीं है तो उसको action भी नहीं मिलेगा, कोई remedy भी नहीं मिलेगी. Simple as that, nothing very complicated in this one also. So the next is rex non potest pecura, the king can do no wrong. Basically, ठीक है, बहुत सारी चीजें हैं. So it is called the king can do no wrong, rex non potest pecera. That means sovereign immunity. ठीक है? sovereign immunity दी गई है या crown immunity कह सकते हैं, is a legal doctrine by which the sovereignty or the state cannot claim or cannot commit a legal wrong and is immune from civil suit or criminal prosecution. Basically a king can do no wrong. ठीक है? अगर king ने कहा है तो सही है. ठीक है? तो इसको कहते हैं क्राउन इम्यूनिटी. ठीक है? वेरी सिंपल, नथिंग वेरी like important in it. This might not even pop in your exam, but for your knowledge this is very important that you know these kinds of maxims. The next is solus populi est suprema lex. This means the welfare of the people is supreme law. The health, the good salvation, facility and felicity of the people should be the supreme law. Right? The supreme law is that defined in this way, that the welfare of the people is the only supreme law. अगर एक state exist कर रहा है, so that should be for the supremacy and for the welfare of the people, not against the people. It should work for the people. So that is the definition. Solus populi est suprema lex. That is the definition. That is the legal maxim, and the definition is the welfare of the people is the supreme law in this case. Sign die, which means with no day, indefinitely. Adjournment sign die without assigning any day for further meeting or hearing. ठीक है? जब एक चीज को adjourn किया जाता है without giving a further date, then it is called sign die. Right? So adjournment sign die means and without an assignment a day for a further meeting or hearing. Very regularly used term in the Indian judicial system. So आपको ये term भी देखने को मिल जाएगी. Right? So this is it for today, guys. I hope you were able to understand all these legal terms that I've told you, and you will get some knowledge and they will be helpful for you in your examinations. So thanks for joining the session. Use your masks, use your hand sanitizer, wash your hands regularly, maintain your social distancing, keep studying, keep preparing, and keep smiling. Thank you, everyone. See you again on Friday with another value added session. And I hope these sessions help you a lot. Thank you, everyone. Take care. Bye-bye. See you all.